Dual intent. So this is an interesting one. How do you prove that you have ties to your home country and likely to return to your home country if you've already applied for permanent residence to Canada? Well, I mean, most likely you're going to be staying in Canada, right? And the officer is going to know this. But the government specifically has provided in Section 22, Sub 2 of the IRPA, the Act, that the intention by a foreign national to become a permanent resident does not preclude them from becoming a temporary resident if the officer is satisfied that they will leave Canada after the period of their authorized stay. So I could be interested in becoming a permanent resident, or I could have applied for permanent residence, but I might be entering Canada as a visitor, and I know that I only have 6 months, and at the end of those 6 months, if I haven't gotten my permanent resident, I'll leave. So we do this pitches all the time. We might have people who are they finish their studies, or maybe they finish their work permit. They already applied for permanent residence. That should be coming in a couple of months. They just want to extend their stay in Canada as a visitor. So we send an application to extend their stay as a visitor. We make the pitch, dual intent. This person wants to wrap up their life here. They're waiting for this to be decided. They're very well, at this point, they're only extending as a visitor. They don't intend to work while they're here. They understand that if their permanent residence doesn't come through, they'll leave. And if the officer is satisfied that what they're applying for at that moment is for temporary entry, then that's not a reason to refuse. But again, it's something that you should argue. If that's the case, it's something that would raise a flag and you need to address it. I would say something that you don't need to address unless the applicant has applied for PR, or it's pretty obvious that they're going to be applying for PR. For instance, if you get a work permit for for an in-home caregiver, and now this has changed because the government has suspended the PR path for them. They're probably going to reopen it. The minister has made all indications that they're going to reopen it. But before, when in-home caregivers had a path to permanent residence, and it was just pretty much completing 2 years of work, I would talk about in ties to home country in my work permit, in the work permit application, that in addition to all these other reasons why the client would go back home, this is an application that has a path to permanent residence. So once the client becomes eligible, they intend to apply for that. And that kind of like makes the officer a little less anxious because they know that the person might have an opportunity to become a permanent resident and they're not going to stay here illegally. That's what they're really, really concerned about. So in that case where a PR application could be imminent, you might want to address it too. And I've provided you the guidelines for dual intent. And I've quoted some few things from the guidelines. So dual intent is present when a foreign national who has applied for permanent residence in Canada also applies to enter as a temporary resident. Having two intents, one for temporary residence and one for permanent residence, is legitimate. You might have to, that's what dual intent is really about. The important part is that dual intent on the part of the applicant is not prima facie grounds for a refusal. The important thing is that you have a good faith and intent to become a temporary resident right now. So basically, if I could be a PR applicant, that application is rolling, but right now I want to come to do a master's in the US. If my intention to do a master's is in good faith, so the reason why I'm entering Canada right now is because of my master's, and that's a good faith intent, and I'm not lying about the master's or using the master's to get my foot into Canada, then I shouldn't be refused for that. But the problem comes from when you have your whole intent is to become permanent resident and you're using your temporary residence as a misrepresentation to do that. So if you've applied for permanent residence and you just sought a 6-month program or an 8-month program in some college because you just want to come to Canada sooner, and the only reason you're doing that program is to come to Canada sooner to become a PR, then that might be an issue. But again, this is how you treat it. It's all about how you treat it. I just want you basically know that just because you apply to PR, it doesn't mean that it doesn't make you eligible for temporary residence. And most importantly, and this you probably find some people advise clients wrong on this, be like, oh, don't mention that you've applied for PR because then they'll think that you want to stay. That's the worst advice that anyone could give. It's so dumb. Starting by the fact that they already know that they applied for PR, like the officer are going to be able to check on their system that this person has applied for PR, and not to mention that they're counseling a misrepresentation, right? So more about the dual intent in the guidelines. The possibility that a foreign national may be approved under PR program in the future does not absolve the foreign national from meeting the requirements of the temporary resident status at the moment. And there's some rigidity in the whole ties to home country because if someone has applied for permanent residence, they might be staying here. And what the government says is that there's the application of Section 22, so the dual intent provision, provides for some flexibility. So if someone is in a set of circumstances that the PR application is near completion, then the officer is probably going to be a little bit more flexible in ties to home country. They might know that they're not likely going to return back home. They might not have many elements in their application to return back home, but their PR application is almost complete, so I'm going to be a little bit more flexible with this person. And some factors they're going to be looking into is like length of time spent in Canada, means of support, compliance with immigration laws, that can be very important, obligations and ties to the home country. So those are things that you're going to want to point out in the application. And again, it depends on the facts. I've had some where I just basically quote the dual intent provision, say that the client has been in good status in Canada. They've always shown that they intend to abide by Canada's immigration laws. They understand that right now they're applying for temporary residence, and should they not get their PR, they'll leave, and that's sufficient. But if I find it's a case that's a little bit more difficult, there might be some refusals there, past visa applications or stuff like that, then I might want to get more into the factors that I've provided here. Okay, so Rishi has a question. Why does dual intent doesn't work in cases where the spouse in India wants to come on a visitor visa while waiting for the decision on spousal application? It does, but officers are just, I mean, that's something that definitely applies to those situations. And the thing though is that the officers might be concerned that if the application doesn't go through, that person is going to stay illegal in Canada. So I've had a lot of clients who have applied for spousal sponsorship who I normally provide them with a letter after that we do the spousal sponsorship application that quotes the dual intent. They say that they've applied, that they're coming in as visitors, that they intend to leave, that they've been counseled on the fact they're going to leave. And if the officer believes them, then they'll let them in. The thing though is just like there's some countries, and I mean not just to single it out, but India is one of those, where a lot of people do applications that are refused, and some applications are fraudulent. So if the officer is concerned that this application is not going to go through, and again, it's not the same officer who's reviewing the spousal sponsorship application, but they feel that there's, given country conditions, given many things, the application might not go through. This person might be overstaying in Canada. So they might decide to say, okay, I'm not going to give this person a TRV. I'm not going to let this person in Canada. We'll just let the spousal sponsorship resolve. But if you have, and again, it all depends on the situation of the client. If you have someone from India who has had visitors visas to Canada in the past, or has had visitors visa to the UK, to Europe, to the US, they travel all the time and they've never overstayed anywhere, then maybe you can make the officer won't be so concerned. But it definitely happens. I mean, that's not to say that just because there's dual intent that any officer is going to be like, okay, there's not going to be any issues. At the end of the day, you have to convince the officer that you're coming in right now for temporary residence and you're going to abide Canadian immigration laws. And just like anything, it's going to depend on the fact pattern that you have in front of you. Do I have any success rates for clients in such cases? Absolutely. Like, I mean, I have a lot of clients who travel a lot to Canada to visit their spouse. They might have been with their spouse outside of Canada. They're doing the application, so the spouse is relocating here. The husband or wife is going back and forth to deal with like work. It's just a matter of including the evidence there. So like if it's, I'll give you an example. It's a wife who's been living with the spouse and children who are Canadian, because the spouse is Canadian, for years. They decide to move to Canada. So like they've relocated to Canada, the spouse and the children. The husband is tying loose ends back home, traveling back and forth. Husband has traveled to Canada in the past as a visitor. Husband travels to a lot of other countries, can show that they have a lot of assets still back home, can show that they still have employment back home. Those are all things that you're going to be able to show there and make use of dual intent provision. Now you have husband who lives here in Canada, is sponsoring a spouse who lives in India, who doesn't have a job, who's never traveled, and has never been to Canada and hasn't been to many countries. Well, that's a situation where the officer might be like, well, I'm not convinced that this person is just going to leave at the end of their 6 months of visitor. So again, it's going to depend on the circumstances that you have, but in either cases, definitely make the pitch for dual intent, because it's something that you know it's going to be raised. You know that the officer is going to consider the fact that this person has applied for PR. You might as well have that in your submissions. And if you get a refusal and you're going to be appealing that at any point or a judicial review, then at least you can make reference to the fact that you refer to that. And if you had a good fact pattern, then, I mean, again, that makes the decision a little bit more unreasonable. Okay, so let's talk about some common mistakes made by study permit applicants. We're getting around like half of the presentation, so I think we'll be good with time. And then maybe after a few of these things, we'll take a break at some point around 2 p.m. So what do I notice when someone comes to my office and they say my application has been refused? And I look at it. What are some kind of the common mistakes, or someone who went with like a representative that wasn't very good? I mean, it could be because they don't do a lot of those applications, or it's just like, I mean, there's a lot of incompetent representatives out there. What are kind of like some common mistakes, or even mistakes that we could have made ourselves and we've learned from those mistakes? So not reviewing the study permit checklist and the country-specific checklist. Again, you can get a refusal saying like, you don't have police certificates. It's specified that for the visa applications from your country, you have to include them. So you don't go with what it says online. Don't go with what it just says on the general checklist. Always look at the country-specific checklist. And that should be based with where you're residing. So you might be an Indian national residing in the United States. If the United States requires specific things, so make sure you include those things. So even if you're applying online, include them. Even if there's no box for that, include them. And the whole thing with the boxes, this is an interesting one, because as all of you know, for online applications, you can send an application to the individual's portal, so the IRCC portal that the applicant might have, or you might use your own representative portal. I like to use my own representative portal unless the client doesn't want to. I prefer to have control over the communications and everything. In the client portal, they say that they're applying for a study permit. That's just going to give them like a list of things to include. They're not going to give them more extra boxes. So everything that's extra that you think should be included, you're likely going to have to put it with a letter of explanation, so your cover letter. When you do it in your representative portal, you have a lot of flexibility. It actually doesn't even it only gives you the boxes for the passport, for the photo, for the use of rep form, and for the general form. But all the other documents, you're going to have to select those boxes and click which ones you want to include. So be mindful of that. If you want to include a lot of stuff about ties to home country, then try to select boxes that apply to that. Sometimes you have to choose things that, I mean, don't really make a lot of sense, but they have some boxes for letter of explanation, for proof of this or that. So make sure you include it. Make sure, like, I mean, very important. General checklist and country-specific checklist. And if you're applying for a study permit and a co-op work permit at the same time, make sure you look at the work permit checklist and the country-specific work permit checklist as well. So another common mistake, assuming that an online checklist contains everything that's necessary. Assuming that documents not requested in the checklist are not important. That's also not true, right? Like, I mean, they might not ask for a birth certificate, but if you want to show that this person has non-accompanying dependents, you might want to include that. None of the checklists really ask about assets, but they're proof of ties to home country, so you might want to include that as well. Making mistakes in the forms. I mean, a lot of clients get stuff returned because they haven't signed, they've made a mistake or something like that. Using the wrong application. I've seen a lot of people who get refused because they did an in-Canada application for a study permit when it was supposed to be an outside of Canada. They didn't qualify for in Canada. So even if they have a really strong case, they're going to get a refusal saying you applied at the wrong place. Okay. And again, this is very embarrassing if you're a representative, because if the client makes this mistake, they'll be like, oh man, I should have used someone. But if they decided to use someone and this person used the wrong form, that's not going to look good. That's a situation where you're going to have to make full disclosure, say that you're sorry, whatever happened, explain what happened, tell your insurer that this happened, and then probably offer the client to do it again without charging them extra money, because that's clearly been your mistake. Not catering documentation to individual circumstances. It drives me nuts when I see people who say, here's the general checklist that we give every single student to apply to Canada. Please provide this. Now, that's not to say that we don't use checklists as precedents. We have a checklist at our firm that we use for study permits. We have one that we use for this type of work permit, but we always revise that checklist based on the applicant. And once we get the documents, if we know that ties to home country is going to be difficult, we might ask for more documents. So again, you cannot use just the same documents that you use for someone for another one. You see what's easy, what are the strengths, you don't over document that, and the weaknesses, and you obviously over document any weakness. Applying too close to commencement of studies. This can be an issue. I've seen refusals that say, let's say, processing time in the visa office is 1 month. Program is about to start in 3 weeks. After the program has started, you get a refusal letter saying, oh, your program already started, so basically refuse it because you're not going to be able to do your program, so be careful about that. Applying in a country they're visiting or where their temporary status is about to expire, this is complicated too. Some people say, oh, I'm visiting my cousin in the US for 3 months, I'm going to apply for my study permit here. Well, I mean, they don't have any ties to the US, so they should be applying back home. Or someone might be living in Dubai, their status is about to expire. Like, I mean, they're going to take that as a situation that they don't have ties to their country where they're applying for. So it's better for them to go back home, resettle there, and then apply from that place where they have their ties. Misrepresenting family composition. Again, this is beyond like a common mistake. This is just an overt misrepresentation. Drives me nuts when people say, oh, you're living with your spouse, you've been living for the last 2 years, but say that you're single. Don't declare common law because you're going to get a refusal. If you're someone who does that kind of stuff, like obviously, I mean, you don't have, like, I mean, you're not finding like a good practice. But it drives me nuts that people hear that from their cousin, they hear that from friends, and they sometimes heard that from like their representatives that they say like, oh, let's not say that you're common law because then it would be more complicated. You have to show more money. They might, it's a reason for a refusal. I mean, if you are common law, you have to declare it. A lot of people get burnt later on because they fail to declare this kind of stuff, and later on they want to get their common law person a spousal work permit, or they're applying for permanent residence and now they're saying they're common law, they've been common law for the last 5 years, and that's inconsistent with what they've been saying. So definitely not a good thing to misrepresent family composition. Failing to consider or include a study plan. As I said, some countries don't require it. But if you think this is one of those situations where you should include one, then include one. I mean, ask your client to prepare one. That's something that I've seen that happen too. Not including all relevant correspondence from the DLI. So sometimes you might have the letter of acceptance, but not other letters that have information about program duration, how much the program costs. You might have just a letter that says, congratulations, you've been admitted to a program, but they don't have like really specific of the program. So that could be reason for a refusal. Being unaware of the financial sufficiency. Sometimes people think that they might need to prove $15,000, but they need to prove $25,000 because they're coming with their family members too. So that could be a common mistake. Seen very often, and again, we'll talk about what's a better way to go about this. Having enough funds but not documenting them properly. Having multiple individuals or distant family support their financially. Again, something else, you know, when you get the student that says, okay, I want to come to study in Canada. How are you going to pay for that? Well, my brother, my cousin, my second cousin, my mom's aunt, and my brother are going to pay for my studies. And you're like, you know what? You're 35 years old, or even like if you're 19 years old, it's really, I mean, I don't know, like it's really out there that you're like need 5 people to support you during your studies. If sibling is enough or his father is enough, then just focus on that one. I mean, sometimes I do find like people just, the father might be making enough to pay for their studies, but they also include their siblings and their cousins just because they want to over document it. That this is probably one of those cases where I would say don't over document. It just looks weird having so many people be able to pay for your studies. If your parent has enough, then just use your parent. If they don't have enough, then you might have to use more people. But the more people you use, the weirder it gets. And again, the most chances for a refusal. And it also looks very weird when you're an adult, 35 years old, have a husband and children, and your dad's still paying for your studies or your brother's still paying for your studies. So again, sometimes you can fix it. Sometimes by just telling the client, well, no, let's just put your dad because he has enough funds. Or sometimes you can, I mean, you just have to warn the client that this might look fishy and they might feel like you don't have enough funds. Ignoring ties to home country. Most people say, oh, that's not in the checklist, I'm not going to include anything. Do you have assets? Yeah, I own a lot of properties. I own all this stuff. I have companies there. Well, I mean, that's something I would have included if I had known all this stuff. They didn't know because, again, that's not provided on their checklist. And here we go back to that whole thing that just like, oh, everything is online. Why do I need to hire someone? Well, because we know what the legal test is. We know that ties to home country is part of the test. That's nowhere in the checklist. So we know, and we also know what kind of thing to include depending on your situation. Failing to pay the right fees. A lot of refusals because of that. Again, it's I sometimes like when people learn the importance of doing things right, and when they don't include, like, let's say like an open work permit fee and they get their application refused, it's just like, well, that's why you use a professional. But again, if this happens to you, it's a terrible mistake. Make sure you have the right fees. Failing to declare immigration representative who assisted them in their application. Again, this could be a reason for a refusal. I've had some people who they go to someone, and sometimes it could be like a travel agent, it could be an education consultant who's not an immigration consultant. And then they say, okay, I'll prepare the application for you. I'll write the letter. It's pretty obvious that they didn't write the letter themselves, that someone else wrote it. They might have used like a copy paste precedent that doesn't even have the right gender pronouns and things like that. So IRCC comes back and says, like, we believe that someone else assisted you in preparing this application. You haven't declared this representative. And there's a lot of issues there, including misrepresentation. It could include the fact that you paid someone who's not authorized to do that. So what I always say is that if I'm involved in an application, if I help prepare a letter, if I gave them if I basically dictated the cover letter to them, I say, you know what? Let's include a use of rep form. I'm not going to be your representative. I'm not going to get any communications, but include the use of rep form because I'm authorized to do this anyway. And then in the cover letter, you're going to say, I've consulted Andrew Carvajal, a lawyer in Toronto, in preparation of this application, and paid for his services. He's not going to be my representative of record, and I wish that all communications come to me directly. In any event, I'm providing a user rep form so that you have his information. And again, that's being upfront. The office is going to say, oh, now it makes sense why this letter is so well drafted. And then that client is not going to get into trouble because they're allowed to pay for you for your advice.